Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below.
How do I apply for a green card from a U.S. consulate or embassy outside the United States?
Let's find out. The green card application process from outside the United States is known as consular processing, where the non-citizen seeking the green card is applying for what is known as an immigrant visa. Obtaining the immigrant visa is essentially the same as obtaining a green card, where lawful permanent resident status is conferred on the non-citizen upon his entry into the United States, after an immigration officer inspects the immigrant visa, and allows entry into the United States based on possession of the immigrant visa. A non-citizen would likely be applying for lawful permanent resident status, either via a family-based green card petition or employment-based green card petition, where the non-citizen will need to complete the application process by applying for the immigrant visa through the Department of State in either circumstance. If an application is required through the consulate, this can be viewed as the second step after the first step of submitting the initial green card petition with the United States Citizenship and Immigration Service, USCIS. For green cards based on a family relationship, the petition to be processed by USCIS is known as the I-130 petition, while the employment-based petition is known as an I-140 petition. It is important to understand that while both USCIS and the Department of State are agencies within the U.S. government that work with each other in processing green card applications abroad, they are still two different agencies requiring two separate applications with each agency, to eventually complete the goal of the non-citizen receiving the eventual green card.
Let's talk about applying for the immigrant visa.
Upon processing and approval of the initial immigration petition with USCIS, USCIS notifies the Department of State of the approval, causing the Department of State, through a sub-office known as the National Visa Center or NVC, to create the visa case in the NVC's system, known as the Consular Electronic Application Center or CEAC.
Once the case is created in the CEAC, the NVC then sends a welcome notice to the applicant and legal representative for the non-citizen beneficiary, providing the immigrant visa case number and invoice ID number with corresponding instructions for creating an account in the CEAC system, including instructions to pay the immigrant visa application fees. After the fees are paid, the applicant will be able to fill in the application form online, known as the DS-260, and upload what are known as the civil documents, in support of the application to the CEAC system. Civil documents vary from consulate to consulate, but are typically documents such as birth certificates, marriage certificates and passports. Furthermore, depending on the employment eligibility criteria for a green card, a non-citizen may also need to provide documentation demonstrating that he meets such eligibility criteria. In all family-based cases, the petitioning family member must also complete and upload USCIS Form I-864, which reports the number of family members being supported for green cards, and the financial income and asset information of the petitioner, or if needed, of a financial co-sponsor. The petitioner, and if there is a co-sponsor, the co-sponsor must also upload to the CEAC system their income tax returns to support the income reported in the I-864. Once all required documents have been uploaded and the DS-260 has been completed, the NVC will begin to review the application and supporting documents, to determine whether the application is documentarily complete, to schedule the immigrant visa interview at the consulate post. Otherwise, if the application is considered to be deficient, the NVC will notify the applicant with instructions to provide additional information or provide additional documents. If the application is determined to be complete and the interview date is scheduled, the case will then be sent from the NVC to the consular post for the review and final decision by a consular officer.
What about the consular interview?
Before the interview, the beneficiary and any derivative applicant are required to schedule a medical appointment with an authorized physician in the country where the interview will take place. This exam must be with an embassy-approved doctor, also referred to as the panel physician. Exams conducted by other physicians will not be accepted. The medical examination, along with any required vaccinations, must be completed before the scheduled visa interview date. At the interview, the beneficiary is expected to bring certain documents such as the appointment letter, the DS-260 confirmation page, photographs and original or certified copy version of all civil documents submitted to the NVC. Furthermore, as previously mentioned, employment-based cases may also require the non-citizen to also bring documentation demonstrating eligibility under employment category the green card is being applied under. The officer will then interview the beneficiary and decide whether to approve or deny the application. If denied, it may be that the officer requires additional information or documents before making a decision and will advise the beneficiary of the additional information or documents needed and how to provide them. If an officer determines that the non-citizen is ineligible for the green card, the non-citizen should seek assistance of an immigration attorney to determine how the non-citizen may be ineligible, and if it is possible to overcome the ineligibility. In most cases, if the officer determines a non-citizen is ineligible, but the ineligibility may be overcome, the officer will indicate to the non-citizen the possibility of overcoming the ineligibility, and allow the non-citizen opportunity to overcome the ineligibility issue. Some cases may require further review known as administrative processing, which could be based on many different reasons, but is most typically caused by a security concern in the non-citizen's background that requires more thorough security checks. If the case is approved, the officer will provide instructions on when the passport and visa will be returned, or ready for pickup after the interview. Once the beneficiary receives the passport and visa, he must travel to the United States no later than the visa expiration date printed on the visa. The non-citizen must also pay an immigrant fee. Once the beneficiary enters the United States, he will be processed by a Customs and Border Protection agent, who has authority to admit non-citizens to the United States. Once the beneficiary is admitted and has paid the immigrant fee, he is considered a lawful permanent resident or a green card holder. The actual green card itself will then be mailed to the new lawful permanent resident once USCIS receives notification from the inspecting officer's office of the lawful permanent resident's lawful admission into the United States. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide, any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.